Hello, everyone. We'll just wait a couple of minutes as the participants enter the room. Thank you all for joining us today. Okay, I think we'll go ahead and get started. Hello, everyone. Welcome to today's episode of the EU Renew webinar series on Europe in the World. I am Jed Odermatt of the Leuven Center for Global Governance Studies, and I will be your host and moderator today. We are joined by Dr. Jed Odermatt, who will be discussing his new book, International Law and the European Union, which was published in 2021 by Cambridge University Press. Dr. Jed Odermatt is a senior lecturer at the City Law School of the City University of London, where he is co-convener of the International Law and Affairs Group and member of the Institute for the Study of European Law. His research interests relate to public international law, international dispute settlement, the law of international organizations, and EU external relations law. He is a member of the Coordinating Committee of the European Society of International Law Interest Group, EU as a global actor, and co-rapporteur of the International Law Association Study Group, International Law of Regional Organizations. Jed also teaches and supervises in the areas of public international law and international human rights law. Also joining us today as expert discussant is Professor Dr. Fernanda Nicola. She is professor of law at the Washington College of Law at American University, and she is the director of the program on international organizations law and development. Her research and teaching interests are in European Union law, constitutional law, comparative law, and local government law, and she has published very extensively on these subjects. We will begin today's webinar with a presentation by Jed of approximately 25-30 minutes, and then we'll turn to Fernanda to kick off the discussion by offering some reflections and asking a few questions, to which Jed will have a first opportunity to respond. But then we'll turn to questions from you, the audience. So feel free to send questions for me or questions for the speakers at any time throughout the webinar by using the webinar Q&A function at the bottom of the Zoom window. You'll be able to see it. If you just scroll down, you might have to use your cursor to make the window alive, but you'll see a Q&A box at the bottom. Use that to send your questions. Before we begin, just a few words about the EU Renew project. The EU Research and Education Network on Europe and the World, or EU Renew as we call it, is an Erasmus Jean Monnet network bringing together 19 higher education institutions from Europe, Asia, Africa, and the Americas, with the goal of improving knowledge and enhancing debate on the EU's role in an ever-changing world. On behalf of EU Renew, I would like to really thank Jed and Fernanda for joining us today. And it is my great pleasure now to pass the floor to Jed.
Thank you. Thanks for the invitation as well. It's a pleasure to also be virtually at the Leuven Center for Global Governance Studies, where I did most of the research for this book when I was a PhD researcher with Professor Jan Wouters there. So it was a pleasure to also be kind of virtually back in Leuven. And I'll give you a kind of an overview of the book today before we have the discussion. There's a lot in there, I think. I mean, I've got the copy here. What I wanted to focus on was more some of the conceptual issues that I faced in the book, rather than kind of giving an overview over every single chapter and every argument, to kind of go through that. So the book, International Law and the European Union. So it was only last year in the place I am now, the United Kingdom, where there was this row between the UK and the European Union over the diplomatic status that would be afforded to the European Union in London, where the British authorities thought it would be best to treat the European Union as any other international organization. It's not a state, so why should it be afforded diplomatic status similar to that of a state? Without going into a lot of detail on the whole dispute, I know that Leuven had a whole seminar on this at the time. The EU's High Representative rejected this and said this does not reflect the specific character of the European Union, nor the future relationship between the UK and the EU. Now, I'm not going to go into detail on this diplomatic row. It was also diplomatically resolved between the EU and the UK. But I begin with this discussion just to show you that questions about the EU, what it is, its place in the world, and its status in international law isn't just something we discuss in books and articles and textbooks, but it's something that has enduring relevance practically. And I'll give some more examples as I discuss this. So this question about what the European Union is, an unidentified legal object, continues to be something which is debated in articles, books, but also is something debated in international organizations, international courts and tribunals, dispute settlement bodies, in negotiations between the EU and third states. And so this idea of the EU as a UPO, I have this quote from Jacques Delors, is now continuing to be one of a ULO, a unidentified legal object. Now, this is something that I address because it's something that comes up a lot in the research for this book on international law and the European Union. And the focus of the book is to look at the effect that the European Union has had on international law. And that goes and kind of flips the question a bit from what had previously been looked at, was how international law affects the European Union. That is, how has the EU's role on the international stage meant that international law has had to adapt and accommodate this new type of actor? And I said I'm not going to go into detail, but you'll see in the book that I go through each of these kind of foundational issues of international law, like you would find in an international law textbook: customary international law, the law of treaties, international organizations, responsibility, and international dispute settlement. And in each of those areas, I focus on the issues that have arisen from a public international law perspective from the European Union's action on the international stage. So to take the law of treaties, for example, when the European Union joins a treaty, then there are lots of international law issues regarding mixity and so on that will be complicating the whole issue because the European Union is there. Similarly, when the EU takes part in international organizations and so on. So the aim is to look at how international law reacts to and accommodates this distinct type of international actor. And as you can see, this kind of research question brought to light these diverging views about what the European Union is, the very nature of the European Union from an international law perspective. And it's something I wanted to reflect on today, this challenge we have, especially people who work in international law and EU law, of somehow integrating these multiple perspectives. We have different academic communities. We have people, a lot of them in Leuven, who are working on EU external relations law, focusing on what I see as the internal legal issues for the European Union legal order, for the EU member states, that arise from the EU's activity on the international plane. Think of issues such as competences or representation, these kind of issues that are really foundational issues for the European Union legal order. And these are important issues for the EU legal order. But I wanted to also focus on legal issues that arose for international law from the EU's external relations. And these are also important, not only for the EU member states, but also for the non-EU member states, sometimes called third parties, right? Third states. These are also affected by the EU's action on the international plane. And sometimes the narrative is that international law tends to ignore the European Union, overlook the European Union. What I found was, rather than having a blind spot, what we find is that international law scholars tend to treat the European Union as just one of another type of international organization. Yes, it may be special, maybe it's unique, but it still can be categorized as a type of international organization and understood through the lens of the law of international organizations. And so we find these diverging views on the very nature of the European Union. What I call the EU law view, that is, that the EU is a unique legal order, even a sui generis legal order on the international plane. It's a constitutional legal order, and its legal system, EU law, can be treated for the most part as domestic law. And the European Union and its legal order is autonomous. It has its own rules for the creation, interpretation, and application of norms internally, outside of the system of public international law. And while this, I think, works very well internally in its own internal legal sphere, this conception of the European Union is often opposed when the EU goes out into the world, when it tries to expose that narrative to third states and international organizations. And then we can contrast this with the international law view of the European Union, which often accepts the EU as unique, as special, something different, but rejects that we should draw legal consequences from this difference. It rejects the idea that the European Union has transformed into something which is conceptually different from other international organizations, that it has moved on to something which is different from other types of multilateral institutions that exist. And even within the international law view, there are divergent views. There are different ways of conceiving the EU. Some see the EU as best seen as a self-contained regime, a type of subsystem of public international law. It has its own internal legal rules, but it will always fall back on secondary international law rules. Or some, including sometimes you see the European Commission and the EU member states, pushing forward this idea of, well, the EU is a regional economic integration organization, that there's some kind of new legal category of international organization, which the EU is really the only one of, but it's a regional integration organization, a special type of IO. And then there are the international lawyers who don't really see the EU as unique at all and think, well, it's just some kind of classic international organization, which can just be studied and analyzed in the same way as the United Nations or the World Meteorological Organization. And I don't want you to kind of analyze this slide in detail. This is in the book, and I discuss it in a bit more length. But I just put this there to show you the 4 different types of kind of ideal types. No scholars really accept all of these, but these are the 4 ways I understood the EU is understood in international law. The left-hand side being whether or not you understand the EU in its internal sphere, the right approaching the external sphere, and then the above and below really looking at whether or not you accept the EU as a high degree of autonomy and very unique in international law, or at the bottom, whether it exists in existing categories. Now, I put these out here in the opening chapter of the book because they come up when I analyze these kind of practical legal questions later on to see how these conceptions of the EU play out in reality. And what I found is whether or not you think of the EU as fitting in one of these categories often depends on where you start. Often, the conception comes because you have to analyze a particular legal question. What if there is a clash between EU law, international law, and domestic law? Which legal provisions do you look at first? Do you pick up a copy of your own domestic constitution to answer the question? Or maybe you're an EU lawyer and you think the best place to start are the EU treaties and EU law. Or maybe your background is in public international law and you think the best place to resolve a clash is through the UN Charter or the Vienna Convention on the Law of Treaties. Often these starting points end up shaping how you view and conceive of the European Union. Now, I've just illustrated all these different divergent views. This is the point where I usually get the question, Jed, which one is correct? You spent all this time working on this project. Tell me, what's the right answer? Which view is correct? And that's not the point of this research. Rather, what I'm trying to show is how these different conceptions of the European Union play out in these different legal settings. I'm not trying to show you a theory of European Union that applies in all different circumstances, but to show and elaborate how these different conceptions arise, depending on whether the author or the lawyer is analyzing the internal or the external sphere, whether they're in negotiations with a third state on a treaty, or whether they're negotiating in the United Nations. We have all these different kind of views. And I think this was captured in what's now often quoted quote from the Electrobel in Hungary decision on jurisdiction, when the arbitral tribunal was looking at whether or not EU law made up part of the applicable law for the tribunal, and said, well, it depends on the perspective from which EU law is analyzed. Is it looked at from the perspective of the international community, from the perspective of the EU member states, or from the EU institutions? Depending on which perspective you have, you'll have a different understanding of what European Union law is. And I mentioned how this diverging views of the European Union legal order gives rise to practical problems. The one we're seeing today is often before international dispute settlement bodies, particularly arbitral tribunals in the field of investment, where these questions about international law and the European Union continue to arise. And I'm not going to be able to go into all the detail about the background of the kind of so-called intra-EU objection before arbitral tribunals. Basically, we have the European Commission and EU member states objecting to the jurisdiction of some arbitral tribunals in inter-EU disputes, and they base this on EU law, on the Comstroy and Achmea decisions, which many of you will have been familiar with. And this, for the most part, has been rejected by those institutions, by those tribunals. Basically, often saying, well, this is an objection that comes from the internal legal order of the European Union and is not applicable when dealing with international law issues before an international tribunal. We can go into more detail on that. I know that's one slide on that topic, which is much more complicated, but just to show you this divergent views of what the European Union is continues to have practical legal consequences. I'm also interested in what explains these divergent views of the European Union and international law. A bit of a sociological reflection, I guess, on where these come from. And one of them I noticed is because of academic specialization. People often attach themselves to a particular field of law and say, I'm an EU lawyer, therefore I think X. I'm an international lawyer, so my view is Y. People often attach to themselves not only to a specific field of EU law or international law, but see themselves as part of a professional community which is involved in a specific project. Public international lawyers may be attaching themselves to the project of international human rights law, trade law, investment law. An EU lawyer may have the same thing and have an attachment to that specific project. I find time and again that there are these divergent views that coming from how a person situates themselves within their discipline. Another, perhaps, explanation for this is a problem with international law, and that is the state-centrism of international law. That time and time again, we see that international law doesn't have the tools, conceptual tools, to kind of understand these composite legal entities, that something is a state or it's something else. Maybe it's an international organization, maybe it's something else. But when you have a new legal entity or a unique legal entity such as the European Union, it doesn't have the vocabulary to explain something like the European Union. So it uses terminology such as international organization or things like sui generis, which is not a good description. Another explanation is not related really to legal disagreements at all, but rather the interests and values that are underpinning a lot of these divergent views. If we look at some of the clashes between EU law and international law that have taken place over the last 10, 20 years, dealing with sanctions regimes, data protection, animal welfare, the best way to deal with man-made climate change, or even investment arbitration. These are not necessarily coming from divergent views on how to interpret the UN Charter or the Vienna Convention, the law of treaties, or the treaties on the European Union, but relate to kind of values and interests of the European Union. And I think this is shown very well with the ongoing debates about the EU and the best way to deal with climate change. right? These end up before international dispute settlement bodies or negotiations, but underneath them is a more basic question of who is better placed to deal with some of these global challenges. Then we see different ways international EU lawyers seek to overcome these divergent views. Some don't see this as a problem at all. Is it a problem at all that there are different conceptions of the European Union? Pluralist visions of international law don't have a problem with seeing the European Union almost like a particle in physics that can exist in multiple states, depending on where it is, depending on the issue that we're dealing with, depending on the power relations. Is the European Union negotiating with the United States, or is it negotiating a treaty with Afghanistan? In the second, maybe it can push its own narrative a bit further, but it will be rejected when it deals with a more powerful state. But then there's the problem of legal certainty. If we have the EU existing in these multiple states, depending on the forum and the situation, this means that third states have to deal with a very complicated and ever-changing type of international actor. And we see attempts of kind of constitutionalists who've tried to find ways to come up with this theory of everything, to integrate the EU law and international law into each other's systems, to find a way to deal with these clashes, yet to no avail. And we see that often international law is accommodating to EU law views. This is something that's surprising, I think, and came out from the project, that we see in certain situations, third states and international law has accepted the EU's unique status in certain circumstances, especially when it comes to things like the law of treaties. But this is mostly where third states have, over time, consented to unique rules applicable to the European Union, and can even be seen as pushing forward customary international law. What continues to be rejected, however, is when the EU seeks to apply its own concepts, especially things like the autonomy of the legal order, externally, vis-a-vis third parties, third states who have not given their consent to European Union law. And so I'll just leave you with what I think as the future of the debates about the EU and international law. Early debates about the European Union and international law were really about the EU's origins. They dealt with questions about whether the EU should be understood as a creature of international law. The EU was first created through treaties, which are public international law instruments. But then there was the argument that the EU has transformed into something else, a new legal order, a special legal order, something which may have escaped its international law origins. But later debates, as the EU legal order matured and moved on, looked at this issue of influence. And that is, how does international law affect the European Union? And how does it apply, and how is it given effect within the EU legal order? And so we had questions about international law and its effect over time on the European Union and the EU legal order. But I think what the current debates in this field are now moving on to the issue of interactions. What do I mean by that? It's not only about international law influencing the EU, but vice versa. The way EU can also have an impact on the international legal order. But as the EU legal order becomes more mature, it also becomes more defensive. And as we see in these debates, but also in the way actors such as the EU Court of Justice have viewed international law, is much more defensive. And international law in these debates is not seen as so much of an influencer, but now as a threat to international law, something which can undermine the integrity of the EU and its legal order. I think I can leave it there. Thank you for your attention, and I will now move to Fernanda's comments and your questions. Thank you.
Thank you very much, Jed, for this very interesting overview. I know you had to summarize a lot in a short period of time. So now we'll turn to Fernanda for her reflections and comments and hopefully some questions to kickstart the debate. But I also want to remind the audience that they can start sending in their questions through the Q&A button at the bottom of the webinar window. Over to you, Fernanda.
Thank you, Carrie. Thank you so much, Jed. This presentation was very helpful. I want to go through some things you said and then ask you several questions. In all of that in 10 minutes. So first of all, let me tell you that I met Jed at iCourts, and I think I didn't know it was coming from Leuven, but I can see now that. And I spoke to Jan Wouters last week, and we were talking about your book. I think what's really original and helpful is the analytics that Jed puts out in his book at page 21. Very early on, we saw the chart with the analytic and the kind of genealogy of where these analytics come from, of these models of EU law in international law. And so we have the so-called internal and external sphere, and we have these kind of these two kind of views of in the internal sphere, a very the EU is this new legal order. It comes up early on in the 60s with the Wangen and Luce decision. On the other hand, we have this external sphere where the EU is also this kind of high autonomies, regional international integration organization, and that's somehow deployed in the GATT and then the WTO as this very special status under Article 24 of the GATT. So I think that's super helpful. And I wanted to push a little bit on this genealogy in terms of Jed gives us these three stages of the evolution in a Weilerian, very the phases of EU law and international law, this early creature, as he mentioned, in international law. Then second stage is EU law is somehow following and is bound by international law principle. And I was thinking of Internationalen Geschaft, the EU law starts following human rights law. And finally, he finishes with this third phase of CARI, of clashes between EU law and international legal order. And his analytics here plays a big role. You can really use this analytic of internal versus external, different visions of EU law as a self-contained regime as opposed to a classic international organization in these clashes and how this is used in practice. So let me just bring history a little bit to the fore. And my first question is about this genealogy. And I'm wondering whether the genealogy should start earlier and continue after CARI. And so if we start earlier and we push against the tabula rasa perspective that the EU, it's created, and of course, positivist views are the EU is created with the coal and steel community, and then with the European Economic Community in the 58. But if you go before that in the League of Nations and like European countries collaborating together with the League of Nations, I'm thinking of the work of Jamie Martin in the Meddlers and legal historians, you see there's a certain continuity that we cannot really erase. Therefore, this idea that the Europeans saw themselves already as somehow differently as colonial powers, as powers that were committed to development and created a higher order in international law was already there. And therefore, I do think plays a role in this genealogy that Jed puts out there in terms of, I would say, today with the war in Ukraine, we see, I'm not going as far as Timothy Garton Ash position that the EU is, he calls it a post-empire kind of situation or a new empire. But I think there's something there about this continuity prior to 1950s and after 2020 with Ukrainian war about this idea of, we are another international organization, but guess what? We are the place where colonialism started, where the League of Nations started. There's no surprise that the first president of the ECJ was also a member of the League of Nations. Massimo Pilotti, who supported the invasion of Ethiopia and Eritrea by the fascist regime and all that. But so I'm pushing a bit forward your genealogy. I'm wondering if we could stretch this timeline and see what other considerations. But I know for the purpose of this book, this is already a master accomplishment, and I want to push you there. And I really enjoy the analytics, and I'm wondering if you look at the longue durée of the European history in this more colonial, post-colonial, and neo-colonial perspective, where does this analytic takes us? The two examples I want to engage with in the book that I really enjoyed, and I think the book is very unique for this, is two chapters that I'm passionate about because of where I come from. I have a program on international organizations that we run here in DC, and the two chapters are the European Union in international organizations, and the other one is the European Union in international dispute settlement. So there's correlations between these chapters, and the first chapter I think is super original because I haven't seen a study so methodic about what's the role of the EU in these different organizations, and we're talking here about many different international organizations, where the EU has different status, different powers, participates in different ways. And then if we take, for instance, the classic WTO or the UN, we see really the disparities in which the EU is treated in these two big organizations. But we also see, if we take the WTO that Jed looks at very closely, and its dispute settlement body, we see how the EU is very powerful within the WTO. And the same thing in, for instance, the World Bank that I study a lot. The EU is really a very powerful actor that acts as 100-pound gorilla. You can see even when the EU sits, you have the representatives of the member states plus the representative of the Commission. They talk depending on the complex mixed competences that Jed was mentioning. But really, the question is, the EU gets so much more power when they do act together, and they manage to get like the position they get at the WTO through their regional economic integration organization position. They are very powerful, so powerful that in a way, as Jed points out in the book, countries in Mercosur, CARICOM, ASEAN do not get the same recognition at the EU. So when the EU makes it and succeed in getting all this power, it gets really the possibility to shake things, set up rules in the World Bank with the US. Of course, right now there's a huge restructuring, and the climate bank is really driven by European and American interests in reshaping the bank from a development bank into a climate bank. And so the power is enormous when the EU gets it, and it's presented not just as another international organization, but as a regional economic integration. And in the WTO example, we see it's also a model for the European Court of Justice, where clashes of jurisdiction don't really happen, because in the WTO appellate body jurisdiction, very little clashes between the two legal orders, as Jed points out. Very different from the international dispute settlement, where the European Court of Justice, again, wants to be a model for other regional economic organizations type of institutions, and has pushed very forcefully this idea of being a very some guardian of this autonomy and this self-contained regime, sui generis regime, internal. The European Court of Justice has the last word, knows how to interpret this regime, and therefore has been very clear that there's no way to, as Jed puts it very well, not only the court is the best institution that knows the essential character of EU law, but also does not allow external bodies to interpret EU law. And that has led to the decisions that Jed was mentioning, ACMEA and others in the area of investment arbitration. So this is, I think, these two examples, how the WTO, where the EU is accepted in its whole very powerful, is understood also by a secretariat. In the appellate body, there was a secretariat mostly made by Europeans and a German bureaucrat that was despised by the US. And that's why the Obama administration first, up to the Trump administration, dismantled the dispute settlement because it was considered too European friendly and in a way too deferential to this kind of European understanding of the European Union at this preferential body. And then, of course, we have also the rights of China and the dispute settlement body, and the US not being very happy with that development. But we see that in the other world of the investment dispute settlement, where there's another practice, another sociological practice that is very different, where arbitrators are not extremely focused and they don't want to somehow either understand this very essential character of EU law, and as Jed puts it at the end, very different word, the one of arbitral tribunals and arbitrators, investment arbitrators, that does not defer to these kind of special narrative of EU law as a different legal system. Therefore, the clash is still there. We still have issues with this Nicola judgment, and this arbitral award are still there. The Commission still threatens to say that these are state aids, and they're not, and that's never ending. So I do understand where Jed comes from at the end, saying, well, we have divergent views. Even if you take the WTO and the investment arbitration system, the investment dispute settlement, the views over the EU are really characterized by the EU as another international organization. Why should we delve into its own essentialist debate over autonomy, as opposed to the WTO, where the EU is a regional integration, regional economic integration, which really we give really a lot of weight to its own jurisprudence and its understanding. And so my question is whether these two views are really depending. I would be more in the camp with whether to say, well, this is not so much a problem if you understand the context where you are, and therefore the EU has different powers and different leverages because of its past, whether it's colonial past, its past of a creator of international law in the legal nation, its past of sponsoring global capitalism during the World War II. And so you would see that there the EU, depending on its power vis-a-vis third countries, will definitely have divergentist positions, which are driven by its past, its contribution to international law, and also its current, I would say, current new imperial, if you want to put it, position of its wanting to ally with the US in this kind of new bipolar world that we are creating today. So thank you very much, and I'm happy to continue the conversation.
We'll go directly back to you, Jed, to respond to that, and then we'll take some audience questions.
Yes, thank you for those very thoughtful remarks and questions, which I agree with in many ways. I think, firstly, if you talk about the genealogy, I have a part in the book and also in the presentation where I go through, you said, the kind of different phases and so on. And the purpose of that was not to be a history of the European Union at all. I think if I do more work on this, it's something that would definitely have to be included in there, that goes back further, like you said, to the League of Nations and even earlier, integrating things like the EU and European states and their role in colonialism and so on. And I agree it also goes further, and you gave examples of how this debate continues. When I talk about the genealogy in the book, what I'm focusing on there is what I see as the history of the study of the interaction between the EU and international law and those different phases, having read a lot and seeing those kind of articles written in the 1960s, 70s, and then moving on to, later decades, I saw the debate change. I saw the types of questions change. And I kind of wanted to encapsulate that kind of genealogy. But I think if I work on this more, and the more I see other people working on similar topics, that these issues of the EU and EU member states past is an important question, especially when it comes to issues of colonialism and neo-imperialism that you mentioned. And it continues to have an effect, even when it comes to things like diplomacy, that, this comes up when the EU is trying to negotiate with third states who bring up issues to do with the EU's past, or even I had a first slide of a diplomat who talked about the law of the jungle and so on, which continues to be brought up in international negotiations. I agree with you as well on the idea of the EU is different depending on different kind of areas where you sit, right? This WTO, IDS, dispute settlement. I totally agree with that. And you say, well, is that a problem? I think that we still see, even in 2023, the EU will sometimes be the gorilla, you said, with lots of power, but there are still instances where the EU negotiators might be in a room and where other states will simply ask, why are you here? You have EU states here. What's the role of the European Union? It continues to be something which, even in 2023, you might expect it to be accepted in many instances, but it's not. So in an area like the WTO that you mentioned, over the decades, it has been accepted, but in other areas, the EU continues to kind of fight, as you mentioned in the chapter about EU and international organizations, for status, for relevance, to be able to speak, and so on. These kind of questions continue to arise for the European Union. Not only is there a different attitude from other states and other organizations towards the EU, but we also find a different attitude towards those organizations from the EU as well, particularly when it comes to the body you mentioned, the Court of Justice of the EU. And I don't go through it in much detail in the book, but more in a recent paper, that there's some kind of judicial diplomacy going on, that the Court of Justice deals with those different international dispute settlement bodies differently, and vice versa. So its approach to the WTO dispute settlement system, kind of cases that were quite famous now, but arose in the 90s and early 2000s, are very different than the more confrontationalist attitude you see in some of the cases from the Court of Justice of the EU towards dispute settlement in the field of investment, which I think also means that those arbitrators may not then want to accept the special nature of the EU in that way. And you mentioned lastly that the story continues. There's the genealogy. I think the next step is going to tell the story about the EU as this geopolitical actor, that because it's still a middle power, it has been using multilateral institutions, as you would expect a middle power to do, using international law and so on. But the next stage might be the EU and its relationship with international law as a geopolitical actor, not just trying to act in international organizations through treaties and soft law and so on, but supplying weapons, being a hard, realist actor will be the next stage of this relationship. And this is going to give rise to questions, hard questions for the European Union in areas of responsibility, when it gets involved in more military actions, these kind of things. So the story doesn't end there. It continues as the EU evolves. Hopefully I've, in that answer, kind of touched upon some of the comments. And I really appreciate you provoking me. I continue to work on this area. And I think these are things that I like to continue working on and integrating in my articles and other work. Thanks.
Thank you.
Thank you very much. Did you want to respond to that, Fernanda, or?
I want to say one thing.
Okay, sure.
very quick, just that I totally agree that the sociology that Jed talks about, it's the sociology of the scholarly community, which is very important because he really describes the multiple views, tries to engage with them, shows the difficulty. Like if you enter this word of EU external relation law, he describes it very well. It's a jungle of views and positions, the constitutionalists, the pluralists, the external relations, etc., internationalists, etc. But at the beginning, I was confused when he talked about the practice. I thought he was talking about the practice in terms of, and he has the practice because he talks about, for instance, the practice of the court, etc. But to push him one step further, if he were to do a project on the practice, I was wondering, do you talk about the practice of, for instance, the European Community, the DG Legal Service that deals with this, the European External Action Service that has now a group of a legal service too of 9 lawyers that are dealing with all this practice, or is the practice of the court, the judges of the courts that have to do that? So it's still even unclear to me, where do you say, because while in an international organization, you would have the general counsel. So I'm looking at the World Bank and I'm going to their vice legal presidencies. There's a general counsel's office in various international organizations. The EU has all these various places where the practice of external relations law or international law is practiced. So that would be another book project that I understand was not this one, but your book made me think about that.
Yeah. Thanks. And one of the things that is actually cut, if we talk about the history of this project as a PhD turning into a book, and you, of course, cut things out, you add things in, was the Court of Justice. I kind of focused on one actor, and I have really looking at the Court of Justice and its approaches to international law. That's all taken out, and I'll work in other fields on that. But then the question arises, if you're going to focus on the court as an actor, what about all these other ones? What about the view of the Commission or the EU External Action Service or the member states, these kind of things? I know it's an easy answer for these things. You can always say it's for another project, but I think that's definitely, I take that also as a criticism as well, that you have to simplify things. You say, well, the EU is a bit of a monolith. This is an EU law view, when in reality, things are much more nuanced and there are divergences within EU law. And I did take this as a study mainly looking at scholarly practice, what scholars had written on the EU. And surprisingly finding, or maybe not so surprisingly, that they had accepted a lot of the narrative of the court in those early years, reproducing and kind of restating what they had said. And just a last comment of that, Fernanda, you mentioned that you met me at iCourts. Probably this project is different because I didn't publish right after leaving Leuven. I did spend that time being able to look at a bit more into things like power, sociology, academic practice, and so on. I think it's also been maybe nuanced a bit by that experience as well.
Thank you so much. We'll turn, if we can, to a round of questions from the audience. We'll start with 3 and see if we have time for any more. So our first question is asking if you can comment on which of the views of the EU are in play within the negotiations between the EU and other regional organizations, for instance, Mercosur, particularly given that on one hand, they're both considered to be regional economic integration organizations, as you had noted. But on the other, the EU is quite different from Mercosur, very different from Mercosur, and has this, as you mentioned, what is called a sui generis nature. And then another question is, do you think that international law can continue to evolve to allow for better dealing with this composite legal entity like the EU? In some cases, there's already been these intense negotiations with international organizations, and the EU has gained membership in its own right as its own legal entity. Do you think that there's scope for evolution here in the future? And then finally, I'll choose one that's related to EU in the world, since that's the focus of the project. If you could expand a bit on the EU attempts to apply EU law externally, as you had mentioned earlier in your presentation, are there particular issue areas where this is more in play? Maybe you could speak to that a little bit. We'll start there.
Okay, so there's a question about the EU and its negotiations with Mercosur.
Yes, but I think it could apply more generally to regional organizations and EU relations with regional organizations, and which sort of views of the EU, you mentioned these different views of the EU as a legal entity, which ones are in play, and how does that work with Sure.
Well, one thing I didn't talk about in the presentation, I discussed a bit more in the book, is another form of influence that the EU either has explicitly or not, which is to be a type of forerunner for other international organizations, to be a model for other organizations to emulate. That was also, we talk about genealogy. Once upon a time, there was a time, maybe towards the end of the 90s, early 2000s, seen as this is what would be a good way for another regional organization to pursue economic integration. What I find lately is that this narrative is not as strong. The other regional bodies say we're going to do things our way, maybe differently, maybe take the best practice from the European Union. And there's also, if the EU is, well, it has trade agreements with other blocs, other organizations in the field of trade. This gives rise to one of the topics that was dealt with in the book, which is that of the law of treaties, having different parties, right? Multilateral agreements. Sorry, it's not a multilateral agreement. An agreement with a bilateral agreement with many different parties, right? So this gives rise to questions of the law of treaties when you have so many different parties, plus on top of that an international organization. Issues to do with representation, issues to do with international responsibility, all arise when the EU has relations with international relations with other regional blocs. You wanted me to give an example of some of the ways that the EU seeks to apply its internal legal issues when it comes to other international organizations. And I don't see all the questions, I think, but I saw one question which was to do with the Council of Europe, right? Which got me thinking about the ongoing negotiations, ongoing for as long as I've been discussing and thinking about this topic with the EU. Yes, you know where I'm going. The Convention on Human Rights, which the EU is still in the process of joining, which is an obligation in the EU treaties for the EU to be a party in its own right for the European Convention on Human Rights. And here we don't have a international body that the EU can boss around, that can use its economic and other power to say, look, other Council of Europe member states, you need to do this. Please accept the EU is unique and so on, and include all these all these kind of unique and new types of treaty articles to accept the EU's status. Other countries are not necessarily going to do that. And this is why I use this example throughout the book, where the EU has sought to say, look, we are unique, we have our own legal order. Any negotiation, any treaty between the EU and the other Council of Europe states needs to include special procedures that allow the kind of to take into account the special nature of the EU, the Court of Justice, and so on. As we all know, even the accession agreement, which was accepted by all the member states, institutions, was rejected by the Court of Justice of the EU. There'll be another round of all of this. But I think one of the things we forget is we can't always, or the EU can't always expect other other states outside of the EU legal order to accept that. And I think that's coming from the autonomy of the EU legal order, that narrative, which is not always accepted by Switzerland, by Turkey. Now Russia is not part of this, but another country that rejected this narrative. And we'll find it in areas outside of the negotiations between the Council of Europe member states and the EU. We see it in trade negotiations, pushing forward for things on, I mentioned climate as well, where the EU tries to include much more issues related to kind of normative goals to do with these kind of things, which are also rejected. The EU will push forward saying, well, this is because of its internal legal order that we need to do these things. These are the areas where I see a narrative of rejection of the EU trying to include some of these things in those international agreements. So yeah, that would be one example, I would say, the relationships with the Council of Europe and the accession.
That's great. Thank you so much. Did you have anything else to comment on those questions, or?
Me or Fernanda? Or
You, Jed, yeah.
No, if
That's fine. We were
Yeah.
actually out of time, so
Okay.
it's perfect. Yeah,
Yeah.
I was going to ask you to keep it very, very short, so this is better.
Yeah.
But that is all the time we have for today. But I would really, really like to thank both you, Jed and Fernanda, for joining us today. It was wonderful to have you here and having such experts on this topic, getting into the details and really, really getting into some of the issues. Before leaving you all, I would like to announce that after a short summer break, the EU webinar series will return in September. September 12th, we will bring in Philip Schleifer from the University of Amsterdam on his new book, Global Shifts, Business, Politics, and Deforestation in a Changing World Economy. And you can sign up for that as always at eurenew.eu. And hope to see you again soon. And thank you very much again, Jed and Fernanda, for joining us. From all of us.
Thank you, Carrie.
Thank you and goodbye.
Thanks. Bye.